Alright guys, my name is Christopher Logan Pinter. I am a natural born American citizen and a constitutional law and biblical law scholar. I have no formal education backgrounds. This is all based off of my own independent research into what is wrong with this country, and I have uncovered a lot since the Civil War, and it's time to start breaking it down. Alright, so the first thing we're going to do is we're going to pull up Google here. Switch that over. There we go. Alright, we got Google up right now. We're going to head over and research what does de jure mean. So de jure is according to rightful entitlement or claim by right. The resolution declared that the independent Republic of Latvia, proclaimed on November 18, 1918, was still in existence de jure, denoting something or someone that is rightfully such. He had been de jure king since his father's death. Okay, so now let's look up what does de facto mean. De facto is a legal term meaning in fact or in reality, which is used to qualify many legal concepts even when the formal legal requirements have not been met. De facto law refers to a legal practice or formality that is not specifically enumerated by law. Actual definition: in fact or in effect, whether by right or not. The island has been de facto divided into two countries, denoting someone or something that is such in fact, a de facto one-party system. Origin: de facto, Latin literally of fact. Okay, why am I bringing this up? Let's see. Do you guys know that America is a Republican Union? What is the government of America? It's a federation. I thought we were a confederation, not a federation, which is a federal word. A presidential system. Well, that's true. We are a constitutional republic, but what is a federal republic? The United States is a representative democracy. No, it's a Republican Union. It is a Republican Union, people. What is a federal municipal corporation? A federal municipal corporation is a term that generally refers to a city or town that has been granted certain powers by a state to govern within a geographic area. It is a legal entity established by a state administrator for local governmental affairs. Essentially, it's a form of local government, with the key distinction being its created and powers are derived from the state, not the federal government. So, what is a federal municipal corporation in D.C. mean? So if you're based out of Washington, D.C., the federal city, understanding federal municipal corporation in Washington, D.C. Washington, D.C. holds a unique position within the U.S. political system. It is a federal district that also functions as a municipal corporation, creating a complex and distinct governing structure. Let's break these concepts down. Federal district is the District of Columbia, and it was established as a nation's capital under the exclusive jurisdiction of the U.S. Congress, not the not the de jure union, but the federal corporation. When did this incorporation happen? Let's see if it tells us. Oh, the process of the incorporation, where the Supreme Court began applying the Bill of Rights to states' governments. It happened in these times. Well, what is the Organic Acts of 1871? The District of Columbia Organic Act of 1871 is a congressional act that replaced the individual charters of the cities of Washington and Georgetown with a single territorial government of the entire District of Columbia. This act established a municipal government for the district, consolidating its administration. So when a state or city is incorporated under this act or in this territory, what does that mean? When a state or city is incorporated, it means it has been legally established, not lawfully established by the Constitution, as a municipal corporation under the laws of the state it's located in. This grants the city or town certain powers and responsibilities, including the ability to govern itself, provide services and collect taxes. Essentially, incorporation allows a community to operate as a self-governing entity with its own set of rules, regulations, distinct from surrounding county or state. Let's ask AI a little bit more about that. Let's ask Google what Google has to say about it. Imagine a community in a rural area that's been growing, and residents feel the need for local control over things like zoning and infrastructure development. They might decide to incorporate, which involves a process of petitioning the state, meaning certain requirements, and holding an election where residents vote on whether to incorporate or not. If successful, the new municipality would then have its own city, council, mayor, and police force, and the power to levy taxes to fund these services. Sounds like y'all's local governments. You know, Amarillo Municipal City Court. The state of Texas is a corporation under this. So, what states and cities in America have incorporated under the District of Columbia? See, now it's hiding it. You ready? We're going to come over here to ChatGPT now. And we're going to ask it the same questions. What's the difference in de jure constitution and de facto corporations under the 14th Amendment? See, it automatically switched it from Constitution to corporation. Again, it did it again. I said corporation. I didn't say corporation. I said constitutional union. See, it's got the constitutional union right here. A de jure constitutional union. A de jure constitutional union refers to a legitimate and lawful union of states or political entities that is officially recognized by the Constitution and the government. Weird. Why are they separate? It's the legally established union formed through proper constitutional processes recognized under the law. Amendment that was ratified under military occupation, meaning it is null and void. Alright guys, got it. Thanks for the clarification. You're specifically asking about the de jure union and de facto corporation in relation to the 14th Amendment, especially under the claim that the amendment was unlawfully ratified under military occupation and as a result is null and void. This touches on some complex, often conscientious, and continuous legal arguments, especially surrounding the 14th Amendment, its ratification, and the concept of union as the United States and corporations as legal entities formed under the Constitution. The claim that the 14th Amendment was ratified under military occupation is a viewpoint often associated with certain legal theories, such as those advanced by some sovereign citizen groups or constitutional theorists. It's not theory, it's law. Let's break this down in the context you're describing. Alright, you guys tell me which one we live in. The de jure union versus de facto corporation in the context of the 14th Amendment. The de jure union is the legitimate and lawful union of states and political entities in the traditional understanding of the United States. This would refer to the Union of States as originally established by the U.S. Constitution. The 14th Amendment controversy is the argument that the 14th Amendment was ratified under military occupation and stems from the period after the Civil War during Reconstruction, 1865 to 1877, when the southern states were under military rule by the federal government. Some argue that because of the southern states were under military occupation and their participation in the ratification process was coerced, and I'll prove that it was, the 14th Amendment was illegally ratified, thus rendering it null and void. The de jure union in this context could be seen as the original pre-Civil War Union of States, which may be argued by some theorists to have been disrupted or violated by the coerced ratification of the 14th Amendment. Key claim: the 14th Amendment was imposed on southern states under duress and military force, thus violating the principle of voluntary consent of the states in joining the Union. As a result, it's believed that the post-Civil War Union with the 14th Amendment is not a de jure union, but rather a de facto union or de facto corporation under the Organic Acts of the District of Columbia. A de facto corporation is an entity that operates as a corporation but lacks the full legal recognition or status of a de jure corporation. In the context of the 14th Amendment, some argue that the federal government and certain aspects of U.S. law like civil law, equity law, trust law, common law, civil law, family courts, statutory courts, federal courts, it's all bullshit, guys. It's all bullshit. under a de facto status, meaning they operate as if they were properly constituted, but are not truly authorized or lawfully created according to the original Constitution. Alright, now I'm going to bring up congress.gov. I'm going to bring up this, and we're going to type in 1967 113-12. Notice how it's only pulling up modern times. Weird. Here, I know a shortcut. We'll come over here to one Amnesty Coalition. I'm not a part of this group. I'm just using their website as a the understanding of everything that's going on in our country. That is not what I meant to click on. Come over here to his Williams and Williams and difference between state and federal government. Notice how it's really hard to read all this. But we can come over here to treaty on the word person, and we will come to trying to find the link. So this is the guy that does it. He's a little crooky. He's a Scientologist, but the problem is he lets these he leads on these Scientology things, and then he takes everybody's freedoms by doing it through his corporation, known as the Amnesty Coalition. But what we can find is automobiles, explanatory, detached to D11, DS11. See, he's got all this information, and it's great. See, he keeps trying to do full eagle-eye public, private man, sole proprietorship, flow chart. See, that's stupid stuff. Alright, we'll find it the hard way. Come over here to the historical, and we're going to type in 113-12. That's weird, it's not there. Okay, let's try 113-12 here. Bound edition 113-12. And search. Alrighty, and now we're going to come through here and we're going to look for let's add a little bit more. 1967. Alright, then we're going to come down till we find 16 or 1500s in the pages. That's not right. See, we're looking for these numbers, but in a bigger range. Sort it. Oh, this one, let's see. See guys, this is all a public record that I'm searching. Congressional record. And we're going to do oldest to newest to get 1967 at the top. Now we're going to scroll through these ones all the way to 60s. This was the last time it was brought up, guys. I mean, I'm not joking. The last time it was brought up was 1967 and stated on the public record that the 14th Amendment is null and void. '37s, '40s, '50s. Next page. Bear with me, guys. They removed it. Let's see if I can still find it though. Almost there. Look at all these movements that are going on. So many of them. The 60s and the 50s and 60s were a busy time, I guess. I mean, there's just so many of them. It's like they're trying to hide something. It's weird, it's only showing volume 112, and I'm asking for volume 113. It's like they don't want y'all to see the truth. See, it's been stripped away. Stripped away, stripped away. Alright, hold on. Here we go. Congressional Record, 1967. This is the United States of American Congressional Record, Proceedings and Debates, the 90th Congressional First Session, Volume 113-12. Happened June 12, 1967 to June 20th, 1967. Pages 15309 to 16558. And when we scroll down to right here, from this page, the 14th Amendment, Equal Protection Law or Tool of Usurpation. Mr. Pryor, Mr. Speaker, I ask unanimous consent that the gentleman from Louisiana, Mr. Rarick, may extend his remarks at this point in the record and include extraneous matter. The Speaker pro tempore. Is there objection to the request of the gentleman from Arkansas? There was no objection. Mr. Rarick, Mr. Speaker, arrogantly ignoring clear-cut expressions in the Constitution of the United States, the declared intent of its drafters, notwithstanding our unelected unelected federal judges read out prohibitions of the Constitution of the United States by adopting the fuzzy haze of the 14th Amendment to legislate their personal ideas, prejudice, theories, guilt complexes, aims, and whims. Through the corporation of intellectual educators, we have subjected ourselves to accept destructive use and the meaning of words and phrases. We blindly accept new meanings and changed values to alter our traditional thought. We have tolerantly permitted habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, the present use and expansion of the 14th Amendment is a sham serving as a crutch and hoodwink to precipitate a quasi-legal approach for overthrow of the tender balances and protections of limitations found in the Constitution. But interestingly enough, the 14th Amendment, whether ratified or not, was but the expression of emotional outpouring of the public sentiment following the war between the states. Its obvious purpose and intent was but to free human beings from ownership as a chattel by other humans. Its aim was no more than to free slaves. As our politically appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government by substituting their personal law rationalized under the 14th Amendment, their actions and verbiage brand them and their team as secessionists, rebels with pens instead of guns, seeking to divide our Union. They must be stopped. Public opinion must be aroused. The Union must and shall be preserved. For the Speaker, I ask to include in the record, following my remarks, House Current Resolution 208 of the Louisiana Legislature urging this Congress to declare the 14th Amendment illegal. Also, I include in the record an informative and well-annotated treatise on the illegality of the 14th Amendment, the play toy of our secessionist judges, which have been prepared by Judge Leander H. Perez of Louisiana. This material referred to follows House Congressional Resolution 208, a current resolution to expose the unconstitutionality of the 14th Amendment. To the Constitution of the United States, not for, keyword of, not for, to interpose the sovereignty of the state of Louisiana against the execution of said amendment in this state. Memorialize the Congress of the United States to repeal its joint resolution by July 28, 1868. Declaring that said amendment had been ratified and to provide for the distribution of certified copies of this resolution, whereas the purported 14th Amendment to the United States Constitution was never lawfully adopted in accordance with the requirements of the United States Constitution, because 11 states of the Union were deprived of their equal suffrage in the Senate in violation of Article 5, when 11 southern states, including Louisiana, were excluded from deliberation and decision in the adoption of the joint resolution proposing said 14th Amendment. Said resolution was not presented to the President of the United States in order that the same should take effect as required by Article 1, Section 7. The proposed amendment was not ratified by 3/4 of the states, but to the contrary, 15 states of then 37 states of the Union rejected the proposed 14th Amendment between the dates of its submission to the states by the Secretary of State on June 16, 1866 and March 24, 1868, thereby nullifying said resolution, making it impossible for ratification by the constitutionally required 3/4 of such states. Said southern states, which were denied their equal Suffrage in the Senate had been recognized by proclamations of the President of the United States to have duly constituted governments with all the powers which belonged to free states of the Union, and the legislatures of 7 of the said states had ratified the 13th Amendment, which would have failed ratification but for the ratification of said 7 southern states, and whereas the Reconstruction Acts of Congress unlawfully overthrew their existing governments, removed their lawfully constituted legislatures by military force, and replaced them with rump legislatures which carried out military orders and pretended to ratify the 14th Amendment. And whereas, in spite of the fact that the Secretary of the State in this first proclamation on July 20th, 1868, expressed doubt as to whether 3/4 or the required states had ratified the 14th Amendment, Congress nevertheless adopted a resolution on July 28, 1868, unlawfully declaring that the 3/4 of the states had ratified the 14th Amendment and directed the Secretary of State to so proclaim. Said joint resolution of Congress and the resulting proclamation of the Secretary of State included the purported ratifications of the military enforced rump lectures of 10 southern states whose lawful legislators had previously rejected said 14th Amendment, and also included purported ratifications by the legislators of the states of Ohio and New Jersey, although they had withdrawn their legislative ratification several months previously. All of which proves absolutely that said 14th Amendment was not adopted in accordance with the mandatory constitutional requirements set forth in the Article 5 of the Constitution, and therefore the Constitution itself strikes with nullity the purported 14th Amendment. Now therefore it be resolved by the legislature of Louisiana, the House of Representatives, and the Senate occurring, that the legislator go on record as exposing the unconstitutionality of the 14th Amendment and interposes the sovereignty of the state of Louisiana against the executive execution of said 14th Amendment against the state of Louisiana and its people. That the legislator of Louisiana opposes the use of the invalid 14th Amendment of the federal courts to impose further unlawful edicts and hardships on its people. That the Congress of the United States, by memorialized by the legislature to repeal its unlawful joint resolution of July 28, 1868, declaring that 3/4 of the states had been ratified for the 14th Amendment to the United States Constitution, and that the legislatures of other states of the Union memorialized to give serious study and consideration to take similar action against the validity of the 14th Amendment and to uphold and support the Constitution of the United States, which strikes said 14th Amendment with nullity, and that copies of this resolution, duly certified together with a copy of the treatise on the unconstitutionality of the 14th Amendment by Judge L.H. Perez, be forwarded to the governors and secretaries of states of each in the Union, and to the secretaries of the United States Senate and House of Congress, and to the Louisiana Congressional Delegation, a copy hereof to be published in the Congressional Record. Val H. M. Deloney, Speaker of the House of Representatives, C.C. Aycock, Lieutenant Governor and President of the Senate. Lieutenant Governor, just like I was saying on my Facebook, Lieutenant Governor, that's a military position. We've been under military rule since, June 16th, 1866, March 24th, 1868. The 14th Amendment is unconstitutional. The purported 14th Amendment to the United States Constitution is and should be held to ineffective, invalid, null, void, and unconstitutional for the following reasons. The joint resolution proposing said amendment was not submitted to or adopted by a constitutional Congress. Article 1, Section 3, and Article 4 of the U.S. Constitution, the joint resolution was not submitted to the President for his approval. Article 1, Section 7. The proposed 14th Amendment was rejected by more than 1/4 of all the states then in the Union, and it was never ratified by 3/4 of all the states in the Union. Article 5. The unconstitutional Congress. The U.S. Constitution provides, Article 1, Section 3, the Senate of the United States shall be comprised of 2 senators from each state. Article 5 provides no state without its consent shall be deprived of its equal suffrage in the Senate. The full fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for adoption of the joint resolution proposing the 14th Amendment is shown by resolutions of protests adopted by the following state legislatures. The New Jersey legislature by resolution on March 27, 1868 protested as follows. The said proposed amendment not having yet received the assent of the 3/4 of the states, which is necessary to make it valid, the natural and constitutional right of the state to withdraw its assent is undeniable. That it being necessary by the Constitution that every amendment to the same should be proposed by 2/3 of both House of Congress, the authors of said proposition, for the purpose of securing the assent of the requisite majority, determined to and did exclude from the said 2 houses 80 representatives from 11 states of the Union, upon this pretense that there were no such states in the Union, but finding that 2/3 of the remainder of the said houses could not be brought to assent to that said proposition, they deliberately formed and carried out the design by mutilating the integrity of the United States Senate, and without any pretext or justification other than the possession of the power without the right, and in palpable violation of the Constitution, ejected a member of their own body representing the state, and thus practically denied to New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of the 2/3 of the said houses. The Alabama legislature protested against being deprived of representation in the act of Congress. The state legislature, by resolution on October 15, 1866, protested as follows. The amendment to the Constitution proposed by this joint resolution is Article 14 is presented to the legislature of Texas for its action thereon under Article 5 of that Constitution. This Article 5, providing the mode of making amendments to that instrument, contemplates the participation by all the states through their representatives in Congress in proposing amendments, as representatives from nearly 1/3 of the states were excluded from the Congress proposing the amendments. The constitutional requirements was not complied with. It was violated in letter and in spirit, and the proposing of these amendments to states which were excluded from all participation in their initiation in Congress is a nullity. Let's see. Texas rejected the 14th Amendment on October 27, 1866. Georgia rejected the 14th Amendment. See, all of this stuff needs to be posted everywhere. Everywhere. All of it. The U.S. Constitution provides Article 1, Section 3, the Senate of the United States shall be composed of 2 senators from each state. Each state, and at the time there was 37 states. But if we keep reading, it goes on to say that, hey, guess what? We've rejected them all the time for 157 years to the day. You know, a little bit more than the day. And it's been specifically pointed out for a repetitive long time. And anybody who says they're a U.S. citizen under the 14th Amendment is a slave. It is a continuation of chattel slavery. You want me to prove it? What is a constructive trust? A constructive trust is a legal mechanism imposed by a court to prevent unjust enrichment, not a traditional trust created by settlers. It's essentially a remedy where a court orders someone who has wrongfully obtained or benefited from property to hold that property in trust for the rightful owners, even if no actual trust was intended. This remedy is often used when someone gains property through fraud, mistake, or other unethical means. So, how is the birth certificate a constructive trust? let's see. It says there's a theory circulating online. We know it's not a theory, and we know it's not sovereign citizenship from what I just showed you. It is a free man movement, by all means. The constructive trust claims, government bankruptcy, and corporate conversion. The theory suggests that the U.S. went off the gold standard in 1933. The government went bankrupt. See, it hides the true facts in plain sight. I'm not making this shit up. We just read it ourselves. We know that in 1868 that the 14th Amendment was unlawfully ratified. So any government bankruptcy or corporate conversion after the fact is unlawful and should be put down like the animals that they are. It is our job to stand up lawfully in the courts of law and put an end to this corruption and usurpation of our powers. Do you want me to see where that exactly is said? All right. Let's see, we'll build off of this right here. Arkansas, North Carolina, Louisiana, South Carolina, Alabama, and Georgia, the Reconstruction Acts of Congress, and all acts and things unlawfully done thereunder were in violation of Article 4, Section 4 of the United States Constitution, which required the United States to guarantee every state in the Union a republican form of government. They violated Article 1, Section 3, and Article 5 of the Constitution, which entitled every state in the Union 2 senators, because under provisions of the unlawful acts of Congress, 10 states were deprived of having 2 senators or equal suffrage in the Senate. You ready? The Secretary of State expressly doubts as to whether 3/4 of the required states had ratified the 14th Amendment as shown by his proclamation, which is a sworn under oath proclamation that this is true. Proclamation of July 20th, 1868. Promptly on July 1st, 1868, a joint resolution was adopted by the Senate and House of Representatives declaring that 3/4 of the several states of the Union had ratified the 14th Amendment. That resolution, however, included purported ratification by the unlawful puppet legislatures of 5 states: Arkansas, North Carolina, Louisiana, South Carolina, and Alabama, which had previously rejected the 14th Amendment by accusation of their lawfully constituted legislatures as above shown. This joint resolution assumed to perform the function of the Secretary of State, in whom Congress, by Act of April 20th, 1818, had vested the function of issuing such proclamation during declaring the ratification of constitutional amendments. Meaning, it's unlawful. You ready? The Constitution strikes the 14th Amendment with nullity. The defenders of the 14th Amendment contend that the U.S. Supreme Court has finally decided upon its validity. Such is not the case. In what is considered the leading case, Coleman v. Miller, 307 U.S. .448.59 South Circuit Court, 972 of the U.S. Supreme Court, it did not uphold the validity of the 14th Amendment. So let's go back to Google and see how they're lying to us. Oh, it's a theory circulating online. Right, guys? You got a straw man identity. The theory posits the government creates a separate legal identity, a straw man, with each birth certificate identified by the capitalized version of an individual's name. The straw man is considered a commercial entity, and all debts and liabilities and taxes are purportedly attributed to this entity, not the physical person. The birth certificate as a trust/bond. The birth certificate is then supposedly considered a trust instrument or a bond. If you go and read it, it even says bond on the paper, with inherent financial value that can be used to wipe out debts or claim assets from the government. Notice, no legal basis. Alright, well, let's go see what's the difference between lawful and legal. While lawful and legal are often used interchangeably, they have subtle differences. Legal typically refers to something that is permitted or authorized by law, while lawful implies not only that something is permitted but by law, but also that it aligns with the spirit and principles of the law, potentially carrying a stronger moral connotation according to legal websites. You ready? We're going to go down to the actual definitions. Legal focuses on conformity with the written or enacted law, meaning statutory laws, guys. It means something is permissible by law following the letter of the law. Lawful focus on conformity with the law in its broader sense, including its principles, purpose, and the proper exercise of authority. See, they don't have authority, but we give them authority because we don't fucking do a thing about it. It means something is in accordance with the spirit of the law, even if not specifically addressed in a statute. See, statute. See, it's in Black's Law Dictionary. See, even Google lies. Lies all the time. In essence, lawful considers the overreaching principles and substance of the law, while legal focuses on adhering to specific procedures and rules within the legal system. Legal focuses on adhering to specific procedures and rules within the legal system. Notice that's the true definition of legal. So whether it's legal or not only applies to 14th Amendment citizens. It's pretty simple, guys. You just gotta be not afraid to do the reading. That's it for today. I showed it to you. It's clear as day. There's a way to fix it, but it takes all of us, the people, every single person in America, to say no to the 14th Amendment citizenship and the statutory corporate charters created under it, which is the entire District of Columbia's federal corporate municipality, in which its subsidiaries are known as state of whatever state you live in and city of whatever city that you reside in. And there's a difference between residing and domicile. It's real simple, guys. It's not that hard to understand. When you reside somewhere, that means you don't have to physically be there. Meaning if you reside in one of these cities or municipalities, you reside in the District of Columbia, instead of being domiciled in your state as a state nationalist, which is a proper place to be standing in law, not a 14th Amendment statutory corporate entity.